We're going to talk today a little bit about what happens at a sentencing hearing for a sexual assault matter. So let's assume you've been convicted or you pled guilty to sexual assault, and it's a pretty serious sexual assault. It's a date rape involving sexual intercourse. So what's going to happen? So the judge is going to order what's called a pre-sentence report, which means you're going to meet with a probation officer, and that probation officer is going to review with you, meet with you, interview you, and go through your basically life history from birth till now. All of your background is going to be open for examination, and there's going to be a written report made on all that. That person, the probation officer, is also going to interview friends, employers, family members as well. And that's going to be all reflected in the report, your entire background. So the more positive it is, the better. So as a lawyer, I'm going to be telling you what to expect there, and we want to make sure it's a good report, so you have to go in with the right attitude. That's first and foremost. And God help you if you don't, because that report's going to be disaster, and you're going to get a longer sentence because your background's going to be no good. So let's assume you're a person with good prior background, you've never been in trouble in life, you're say 25 years old, you unfortunately did this sexual assault, but everything else is going to come up nice in the report as you being never been in trouble before. So that's positive. That's going to at least lessen your sentence a little bit, or at least keep it more towards the lower end of the range. So now I get that report a couple of days before the sentencing hearing, which is about 6 weeks after or 8 weeks after the judge orders the report. And I review it, make sure there's no errors. If there are, I'll point them out to the judge and correct them. I now do my submissions, but I come to court, I provide the judge with a case brief of the range of sentence for sexual assault involving sexual intercourse on a date rape situation in Canada. I can tell you this, that range currently, although it tends to be rising over time, is 2 to 3 years in jail. So that's what you're likely facing. It's very difficult to get 18 months anymore, although there's outlier cases, but that's what you're facing. So my role as an advocate for you is to try and get you to the lower end of that range. Of course, the Crown's probably going to be advocating for 3 years if this is after trial. Occasionally the Crown will agree with me on sentence, but that's typical after trial. I'm going to be doing very careful, thought-out submissions that I prepare in advance. It's going to go on for an hour or two, up to 2 hours, where I outline your background, all your positive antecedents, that you're a good person of prior no criminal record, etc., reviewing the report, going through the case law which applies, and ultimately advocating for, say, a 2-year jail term, which I think is appropriate for you. It's based on the offense and the offender. The offense is not good, obviously, it's aggravated. The offender, you're a good person of prior record. You're 25, you're not, you're reasonably youthful. You deserve 2 years. So I finish my submissions, and they, with the judge, they're done verbally in court, orally, as we call them. The Crown will do their submissions. They advocate, they have their own case brief. Maybe the cases are the same as mine. Maybe there's a couple of different ones. We both do our own careful research. The Crown makes submissions, and then the judge ultimately makes the decision about what sentence is appropriate for you. Now, that's your basic sentencing hearing for sexual assault. Now, the one other mention I want to mention, if you pled guilty, but let's say you admit all the facts except for one aggravating fact that the complainant said, for example, that, let's say you admitted everything sexual assault but sexual intercourse. So you admitted oral sex, touching, etc., but we're saying that didn't happen. Well, we're going to have what's called a Gardner hearing, which is essentially a trial at a sentencing hearing where the complainant testifies about that issue, about all the issues. We admit everything, you would testify, and the judge would have to make a decision about whether that fact has been proven beyond a reasonable doubt as well. That's called a Gardner hearing. After the judge makes the decision on that fact, we then proceed to the submissions on sentence. So that's sexual assault sentencing hearings 101 in a nutshell. Thank you for watching our video. We are absolutely committed to bringing you the best possible criminal and DUI educational videos. If you found this video helpful, please like it and subscribe to our YouTube channel. If you've been charged with a criminal offense in Ontario and require our services, please click on the link in the description below.